It's also a great privilege for me to have an opportunity to ask questions of Justice Ginsburg instead of the other way around. And I want to thank all of you out there who planted questions with me in the hopes that I would ask those questions, but I probably won't ask any of those questions. But let's start, Justice Ginsburg, with the Supreme Court of the United States. You and your court handle the most difficult and the most controversial questions of our day and of our society, involving life, death, voting, property, race, freedom, campaign contributions, all of those things. What's so special about this court? Despite the fact that you decide these controversial questions, the Supreme Court of the United States is the most respected institution in our government, has been for a long time. Tell us about why that is.
Ted, I would add that it is probably the most respected high court in the world. One reason is that we have been involved in passing on ordinary laws and executive actions for constitutionality. In most countries in the world, parliamentary supremacy was deeply rooted, and it wasn't until after World War II that courts abroad began to engage in judicial review for constitutionality. So, just to take a few notable cases, when President Truman decided that the country was at war in Korea and couldn't risk a strike in the steel plants, so he took over the steel mills, and that was challenged. And the court held, Mr. President, you do not have that authority acting alone. You need Congress to be with you. So what did Truman do? The next day, he turned the mills back to the owners. Now, that is remarkable to many courts in the world. We have an excellent police staff at the court, but we have no guns. We do not have our own purse, and yet when the Supreme Court makes a decision like that, probably the most dramatic one was Nixon. And the court said, turn over the tapes, and he did, and resigned from office. So part of it is that the court has been at this for a very long time. And it is accepted. Well, take your famous case, Bush v. Gore. So the court made its decision. I dissented, as you know.
I do know that.
But the next day, the country accepted it. Nobody was rioting in the street. The election had been settled. And it's that the court is a revered institution, and I think that all of the current members have one thing in common. We want to keep it that way. We want to be sure that when we leave the court, it will be in as secure a position as it was in when we became a member.
That leads me to a question. You do decide very controversial cases, and sometimes the dissenting opinions clash with the majority opinions with quite a high level of intensity, and yet the court comes back together every year in October after the final decisions are rendered in June. You all seem to get along personally with one another, notwithstanding the difficult and intense decisions that are made. Is that true? What are your relationships like?
It's the most collegial place I've ever worked, more than any law faculty. And part of it is we know we have to work together to keep the court in the position that it holds. So to take Bush v. Gore as another example, now that was a marathon. You know, we granted review on Saturday, briefs filed Sunday, argument on Monday, decision out on Tuesday. And very soon after, within days, we had our regular January sitting. And we all came together, and it was almost as though nothing had happened. It was the same. We were going on to the new sitting.
Has it always been that way? There was a book written about the court called 9 Scorpions in a Bottle. And I know that does not reflect the relationships that exist today, but some people felt that in past years the justices on the court developed animosity towards one another. So if that's true, what do you think, to what do you attribute the relationships that you have now?
In different periods, the court was collegial and uncollegial, and perhaps the most striking example of an uncollegial court is when President Wilson appointed Louis D. Brandeis to the court. Wilson had appointed McReynolds just before. McReynolds didn't like Jews, so much so that when Brandeis spoke at conference, Justice McReynolds left the room. Every time there's a new court, every time there's a new justice, we take a photograph. The year that Brandeis was appointed, there was no photograph because Justice McReynolds refused to stand next to Justice Brandeis. So there have been animosities on the court from time to time, but I can say that the current court is most collegial.
It's well known, I think, that you and Justice Scalia are very, very good friends and have a wonderful relationship with one another, notwithstanding the fact that his judicial philosophy and your judicial philosophy can be quite distant, and you've dissented from his opinions and vice versa. Is that true about your relationship with Justice Scalia, and what causes that to be true?
I met Justice Scalia for the first time when he was on the faculty of the University of Chicago, and I was teaching at Columbia. He gave a talk. It was about a famous administrative law case that the D.C. Circuit had handed down, Vermont Yankee, and he was severely critical, let's say, of that decision. I disagreed with almost everything he said, but he said it in such an utterly captivating way. So, and even now, Ted, you have been a consumer of our products, and you know that our styles are quite different. So, Nino's style is attention-grabbing, would you say? And mine is, I'd say, moderate and restrained in comparison.
I find it attention-grabbing when you ask me a question and I'm arguing in the court. That gets my attention. Now, both you and Justice Scalia are opera buffs. You go to the opera together sometimes, and I was at the opera. And now I read in the paper that someone has written an opera about Justice Ginsburg and Justice Scalia. Did you know that?
Yeah.
This is true.
Can I get that folder that's on the... But everything in the court is done by seniority. Although I am older than Justice Scalia, he was appointed before I was. So the opera is called Scalia Ginsburg.
And tell us about this opera. I mean, how could you write an opera about the two of you, although I think there's a lot of people out there that would like to take a hand at that. But it's really going to happen. Tell us a little bit about it.
I'm going to show some. This is just a random page from the score, so you see it does exist. This is an opera composed by a young man who advertises himself as a composer, lyricist, and pianist. But he also has a law degree. And in his constitutional law class, he was reading these opinions, Justice Scalia's opinions, my opinions, and he decided that this would make a great opera. And I will give you a sample. This is Justice Scalia's opening aria. It is labeled Rage Aria. And the main refrain goes this way. The justices are blind. How can they possibly spout this? The Constitution says absolutely nothing about this. So that's his opening. And my responsive aria, it's in the style of Verdi, and it goes, you are searching in vain for a bright line solution to a problem that isn't so easy to solve. But the beautiful thing about our Constitution is that, like our society, it can evolve.
I'm sure that every one of us here are going to be wanting and standing in line to see the opera when is it within a year? Do you expect what is the plan?
There's a reading or a singing, I don't know what in February in somewhere around Baltimore. So that will be the first time that the entire score will be played.
Justice Ginsburg, in 1981, Ronald Reagan appointed Justice Sandra Day O'Connor to the court. She was the first woman to serve on the United States Supreme Court. I'll say parenthetically, have been 112 appointments to the Supreme Court, I think. You were 108, is that correct, when you replaced Justice White?
Either 107 or 108.
You were the second woman appointed to the Supreme Court just 20 years ago this year. What did it mean to the court when it finally had a woman justice, and then when you came on the court, 2 women justices? And I'm also going to, you might say what it's like now with 3 justices, female.
When Sandra was asked that question, what does it mean to have a second woman? She said, if you think I'm glad that Ruth Bader Ginsburg has come on board, you cannot imagine the joy of John O'Connor to be no longer the lone male spouse. And I mean, she was there all alone for 12 years. Well, a sign that women were there to stay came when I was appointed. They did a renovation in our robing room. Up until then, there was a bathroom and it was labeled men. So when Sandra was at a conference and the need arose, she had to go back to her chambers. They installed a women's bathroom equal in size to the men's. So things were changing. For every year that we sat together, that Justice O'Connor and I sat together, invariably, one lawyer or another would call me Justice O'Connor. They heard a woman's voice, and they knew that there was a woman, and although we don't speak alike and we don't look alike, now, with 3 of us, no one calls me Justice Sotomayor. No one calls Justice Kagan Justice Ginsburg. It's an exhilarating change. After Sandra left and I was all alone in my corner of the bench, and I did feel lonely, now we're all over because I've been there so long. I sit toward the middle. Elena is on my left and Sonia on my right. And as you well know, Ted, those two women are not shrinking violets. They are very active in the questioning at the court. It's wonderful for the school children who parade in and out to see that women are there, definitely part of the court's operation.
Could you describe, since you mentioned it, the oral argument process? I think most people don't know that the court hears about 75 cases a year, and each case, except in unusual situations, is allotted 1 hour for oral argument. That means each side gets a half an hour. Some people think that the lawyers get up and lecture or give a speech as a part of their oral argument. It's not like that at all. Can you describe what oral argument is like and how much you participate?
Yeah. Let me just say something about the 75 cases that we hear and decide by a full opinion. That 75 comes from a pile of over 8,000. We get over 8,000 petitions for review, and from those we select a very small number. The reason we do that is we see our job as keeping the law of the United States more or less uniform, whether it's a statutory question, a constitutional question. If everybody agrees, if all the lower courts are in agreement, there's no need for us to step in. But when good judges are of different minds on what is the right answer, that's when we step in, so that will not be one U.S. law on the West Coast, another one in the Middle States. So the 75 we get down to that way. The oral argument time, as you said, is half hour aside. That's very precious. The justices come to the bench after having done reams of reading. So I think most of my colleagues start, as I do, by reading the opinions in the lower courts. So I'll read the trial court decision, the Court of Appeals decision. I do that before I turn to the lawyers' briefs, because then I'll know if the lawyers are giving an honest account of what the decision was.
And if they're not, Justice Ginsburg catches them.
And nowadays we have many, many friends, amici curiae, so many that it is not possible for the justices to read all of them. So my law clerks have instructions: read all the green briefs. Everything is color coded, so the light green is supporting the petitioner, dark green the respondent, and then arrange the friend of the court briefs for me in 3 piles. One is skip, that's the largest pile. Another is skim or read pages 9 through 13. It has a new argument that's not in the parties' briefs. And then there's a small pile that says read. Those are the really, really good ones, people who are not just saying, me too. So when we come to the bench, we're very well armed. We're prepared for the hearing of the case. And we ask the questions that we think are the most difficult ones, the ones on which the decision may turn. So the advocates should have a chance to address what's on the decision maker's mind. Now, some lawyers resent our interruptions. They would like us to keep quiet, and they would like to present their prepared spiel. But for me, at least in the days when I was arguing cases, a cold bench, that was just a bench that sat there and listened, was the worst possible, because I had no idea what was in the minds of the judges. Sometimes a question is asked not so much to elicit a response from the lawyer, but to persuade a colleague. And sometimes a justice tries to assist a lawyer who's on the ropes by asking a helpful question. Many lawyers miss that cue because they're so suspicious. But when I come off the bench, I have a pretty good idea where my colleagues are on that case. So we're sometimes talking to each other. We're talking through counsel and not to counsel.
Have you found that certain styles of advocacy by the lawyers work better in the court? Justice Scalia was here before this group a few months ago and talked about advocacy. He's written about that. You must have your own views about what works and what doesn't work. Could you say a word or two about that?
Yeah, I think a well-prepared opening sentence is a good idea. You can get that out.
Sometimes.
And then to ride with the wave, go where the court is taking you, and don't try desperately to get back to the script that you planned. I always had about 4 or 5 points that I wanted, that this is essential for me to say, and the rest I could skip. So I would try to make sure that in the argument I made those points. So if I was responding to a question, then I would immediately pick up on the point that I wanted to get across without leaving a pause that would invite another question.
This raises that many people don't know, but you were an advocate yourself, as you just indicated, before the Supreme Court. You represented cases, you handled cases involving rights of women and discrimination.
And men.
And men where questions of gender discrimination arose. John Roberts argued 39 cases or something like that before he was appointed to the Supreme Court. Does it make a difference that you were yourself an advocate and so know what it's like out there? Or most of your colleagues have not argued. Justice Kagan was the Solicitor General, and so she argued a number of cases that one year. But does it make a difference to be on the court, to have been an advocate?
To me, it does in this respect. I tried to keep my questions tight and not to behave as a professor who's asking a complicated hypothetical that goes on and on and on. So I tried to abbreviate the questions so I'm not cutting into the lawyer's time excessively.
So you, having appreciated what it's like to be interrupted and to listen to speeches in the form of questions, you avoid that yourself. But some of your colleagues have a little bit more a broader latitude towards the question asking process.
Yes, but I have occasionally commented on that. I think we appreciate how precious that half hour is. And we've tried to be more disciplined. It's such a contrast to observe a proceeding in the United States Supreme Court and then do what I'm going to do in February, go to the European Court of Justice. It's the highest court of the European Union. There, the justices sit in magnificent maroon velvet robes and ask no questions at all. They sit through the entire argument. I think it would be very hard for me to stay awake if I were operating on that kind of court.
Could you comment on the confirmation process, and then we'll have some questions from the audience. When you were confirmed 20 years ago, the vote was 97-3. I did not look up who were the 3 senators who voted against you, but I bet you could remember. You could name them. But the process has become very contentious. Just John Roberts, there were 20 plus votes against John Roberts for confirmation. There were more than 40 votes against Justice Alito when he was confirmed. Can you comment on what the confirmation process has become compared to what it was like when you were confirmed?
Justice Breyer and I were confirmed in halcyon days. There had been before that the failed nomination of Judge Robert Bork. There had been Justice Thomas's turbulent nomination. I think the committee was mindful that its public reputation had declined because of those two nominations. So there was a deliberate effort to be civil. There had been no women on the committee, so they enlarged the committee by 2, and they had Senator Feinstein and Carol Mosley Braun were added to the committee. I was nominated in June. Any senator could have put a hold on me so that my hearing wouldn't come up until the new term was underway. And although there were 3 negative votes, none of the 3 tried to stop the confirmation process from occurring speedily. My biggest supporter on the Judiciary Committee was not now our Vice President Joe Biden. He was the chair of the committee, but it was Orrin Hatch. I had, as was announced, a long-term affiliation with the American Civil Liberties Union. Not one senator asked me any questions about that affiliation. My hope is that we will get back to the way it was. You spoke about the Chief and Justice Alito, but it was also true of Justice Kagan and Justice Sotomayor. They had many negative votes. So the great man I knew and loved said that the symbol of the United States really isn't the bald eagle, it's the pendulum. So now I think the pendulum has gone too far in one direction in the handling of judicial nominations, and it should go back to the middle.
I think we all would hope that. Now let's give a hand to Justice Ginsburg. Do we have time for questions? There's time for questions?
We do have time for questions. There are 2 microphones. I would just ask that you go to one of the microphones, identify who you are in your company, and also no questions from the media today, please. Thank you.
And no questions on cases that are pending decision or about to be heard.
Gary?
Thank you. Gary Shapiro, the Consumer Electronics Association. First, I want to thank both of you for your historic leadership in protecting the rights of gay Americans to marry. It was terrific change and necessary in our culture. And thank you so much, Justice Ginsburg, for sharing your thoughts with us today. One thing, as an American and as part of the business community that has troubled me increasingly over the years, and I'd like your view on it, is that there are lots of laws, and they're longer laws, and they're ambiguous laws. And we have the example of how AT&T tried to buy a company they thought they could buy, but with great lawyers, presumably, but yet it was struck down by government and it cost AT&T $4 billion. And I know the business community is always trying to think they're following the laws, but they're ambiguous, they're unclear. And is that putting a greater burden on courts, number one? And number 2, if you had a message to our legislators or you wish they could do something, you had a magic button you could press, what would you like Congress to do differently than they're doing today?
To the first part of your question, many, many laws are ambiguous, dense, can be read in more than one way, sometimes more than 3 or 4 ways. In that respect, our Congress doesn't stand up so well in legislative fora in the world. There seems to be a lack of discipline. One tool that has been used in other places is to have an expert drafting committee go over the provisions and try to detect the ambiguities. But sometimes the ambiguities are deliberate because the question was a political hot potato, and the members of Congress preferred to bunt it to the court to say what the law meant. So, but I think people in the business world who care should let their representatives know that you are having a hard time because laws are unclear.
Next.
Justice Ginsburg, my name is Josh Sachs. I work at Equifax. My question for you is, after same-sex marriage and even same-sex rights as a whole, where do you see the future of equal protection jurisprudence being applied down the road?
Thank you for asking that question, because the Equal Protection Clause is my favorite clause in the Constitution. And I think it shows the genius of our legal system. Let's go back to when it all started in 1787. And the Constitution opens with some beautiful words. We, the people of the United States, in order to form a more perfect union. If you ask the question, who are we the people? Would not include me, because women were not part of the political community until 1920. People were held in human bondage. And even white males in many places could not vote unless they were freeholders, unless they were property owners. So we went from an idea of we the people that was rather confined, and over the course of now more than 2 centuries, that notion, we the people, has become ever more expansive. So people who were once held in slavery, Native Americans did not count in the beginning, women. The Equal Protection Clause has worked to perfect, to form a more perfect union, to perfect we the people. I think that the Founding Fathers had that idea from the start, but they were held back by their times. And you heard the lyric from my Aria about the Constitution, like our society, can evolve.
Terry Mahoney, Comcast Business for Business. Solicitor Olson, let me just say I'm very struck by your integrity as you've evolved, as my perception of you has evolved over the years. Justice Ginsburg, you've always been one of my favorites. Semper Fi, thanks. My question, and please don't take this as an endorsement of the policy that I'm going to ask about, but would be term limits for the Supreme Court, say an 18-year term limit that would give each presidential term 2 nominations. Thank you.
It's a good question, but it's highly hypothetical, because Article 3 of the Constitution says that the judges shall hold their offices during good behavior. And on the whole, federal judges have been a well-behaved lot.
Is that because everybody's watching?
But I think the original idea is to make sure that the judges were going to be independent. The framers did two things. One, gave us life tenure, and two, provided that our salaries cannot be diminished while we hold office. Most places in the world, I would have been gone years ago, because the retirement age starts at 65, 70, 75 tops. So it would take a constitutional amendment to change that. And our Constitution is powerfully hard to amend. As proponents of the Equal Rights Amendment well know, as proponents of statehood for the District of Columbia. So the likelihood that you could galvanize the public to amend Article 3 to put a fixed term. So, some systems, say the Constitutional Council in France has a 9-year non-renewable term. In systems that have a relatively long, but non-renewable term, the notion is we make it non-renewable so that the judges won't court favor from particular constituencies. It's a real problem in the United States in state judiciaries that are elected, but the federal judges are all appointed and sit during good behavior.
It raises the question, should a justice plan his or her retirement to coincide with the office of the president's of the same party, so that if it's a Republican appointee, the justice should wait till there's a Republican president and plan his or her retirement at that point? Does that sort of thing enter anybody's mind?
I think one should stay as long as she can do the job full steam. I suppose there were many people who wanted Justice Brennan and Justice Marshall to leave when a Democrat was president, but they didn't. So that's the number one question is, can you do the job? Can you think as well? Can you write with the same fluency? And you, at my age, you take it year by year. I'm okay this year.
That's for sure.
Good morning, Justice Ginsburg and Mr. Moderator. I am Amber Batchelor with UPS, the United Parcel Service, and we appreciate being here this morning. My question to you is, how do you find peace within yourself if there is a case that's been argued and you don't agree with what the resolution is? How do you find peace when you go home with your family? Because I know a lot of times in the professional arena, we don't know how to define professional and work balance, or personal and work balance. How do you find that?
I think you asked two questions. One concerns when I end up on the losing side. Well, there's a very famous man who said it ain't over until it's over. So think of Lily Ledbetter's case. It was 5-4 on my court. There were 4. I was with the 4, and I wrote for the 4. And my bottom line was, the ball is now in Congress's court to amend Title VII to say what I think Congress meant all along. And inside of 2 years, we had the Lilly Ledbetter Fair Pay Act. Now, for the constitutional question, it takes longer. But if you think of all the great free speech dissents that were written by Holmes and Brandeis around the time of World War I, all of those are the law of the land today, although when they were written, they spoke for only 2 justices. So I am always hopeful that if my opinion does not command a court today, it will in time. And then did you ask a question about work-life balance?
Yes, ma'am.
Well, I have 2 children, and they're 10 years apart. So when my daughter was in school, it was really unusual to have a mother who was a working mom. 10 years later, when my son was in school, there was a tremendous transformation in those years, because there were many mothers who had paying jobs as well in the late 60s and 70s. The greatest asset is to have a supportive spouse, someone who thinks that your work is as important as his. And then at different times, I've lived a rather long life. Sometimes one accommodates to the other. So my husband graduated from law school a year before I did. He had a good job in New York. I transferred from Harvard to Columbia. I got a good job in D.C. in 1980 when President Carter appointed me to the D.C. Circuit. Marty, who was then teaching at Columbia, transferred to Georgetown. So you accommodate to each other at different times in your life.
Thank you.
Last question.
Thank you. My name is Scott Seidel, and I'm with Microsoft. I am honored, Justice Ginsburg, to be in your presence. You have a vibrant spirit and mind, and I can certainly see that, and I appreciate the opportunity to hear you today. My question is, a recent presidential aspirant said that corporations are people, my friend. And referring to no particular case, I'm just curious to hear your thoughts on the personhood. We started out with we the people in your earlier statement, that corporations are becoming the people. Thank you.
Corporations count as a person for some purposes, but not for others. Corporations don't march to the polls to cast their ballot. So, but my answer to your question is sometimes they are considered persons. For example, an entity is entitled to due process just as an individual is. And the same would be true for equal protection. You can't single out one kind of business and say we're going to tax that business more heavily than another. So we will continue to have questions about the extent to which a corporation should be treated in the same manner as an individual in cases where it is appropriate to recognize that a corporation is an artificial entity and is not a flesh and blood person.
Let's, Justice, this is a very, very busy time of year for the court. Each of the justices, particularly Justice Ginsburg, spend an enormous time preparing for oral arguments, reading the briefs, writing opinions or concurring opinions or dissenting opinions. This is an enormous amount of time, and I know how hard Justice Ginsburg works and the energy and effort that she puts into her job in every respect. So the fact that she would take her time to be here with us at not her favorite hour of the day, I think we owe her a great deal of thanks for her time and her thoughtful and revealing remarks about the court. Thank you, Justice Ginsburg.